to get started. In the interest of time, and I'm sure there'll be some other people that will be walking in. You can leave the door open probably. Yeah. And I'll go ahead and manage the session. We've already worked through all the guidelines. Okay, we're going to go ahead and get started. My name's Jeff Apperson. I'm the Vice President for International Relations for the National Center for State Courts. Been working with IOJT for several years. And we have a very distinguished panel today. And I want to first introduce the panel, and then we're going to talk in sequence. I have the Honorable Maureen O'Connor, Chief Justice of the Ohio Supreme Court, Chair of the Conference of Chief Justices of the United States, and she's also President of the Board of Directors for the National Center for State Courts. Also, we have the Honorable Adolfo Escuna, who, as you know, is Chancellor of the Philippine Judicial Academy. We have the Honorable Wojciech Postolski, Secretary General of the European Judicial Training Network. And from Brazil, just flew in last night, and she'll be flying back out tonight. She came in for this session, very important, is Ms. Roberta Solis. Ribeiro Martins, who's Judicial Integrity Team Leader for the United Nations Office on Drugs and Crime. Basically, we're going to be talking about the new Global Judicial Integrity Network. And I think that's one of the reasons this is a very compelling session, in that the network is now very active. And I know I just returned from a meeting of all the Chief Justices for Sub-Saharan Africa on this topic. So it's developing. All of our speakers will be very relative. I know Wojciech and I were together in Vienna recently on this topic. We're going to start with, basically the topic is values and ethics, approaches to integrity and accountability training for judges. So it fits with the themes. We're going to start off with Judge Postolski, who's going to give us basically an overview of the European approach. And then we're going to save questions for the end. We're going to have 15 minutes per speaker and save questions to the end. So maybe we'll have time for a discussion on the topics. I think public trust and accountability in that relationship is a critical relationship that we need to focus on right now. So, Judge, thank you.
Thank you very much. Good afternoon, ladies and gentlemen. Sitting on panel with such esteemed colleagues makes me feel quite awkward, because what I intend to do is to share with you a few very simple ideas that we have in mind in EU and addressing judges with the training on the issues related to integrity and the ethics. And to be more concrete, after some introductory remarks, where are we with this process in the EU, I just wish to share with you our experience with one project that appears to be very successfully run in very many EU member states, that is run by EJTN, so the network that I have an honor to chair. Just to let you know, to understand better where all those remarks that I will be sharing with you are coming from, a few words about what EJTN is. EJTN is European Judicial Training Network. So this is the institution based in Brussels, in Belgium, where the headquarters of European Union are, and being a network of all public institutions that are training judges and prosecutors. We address both in all 28 EU member states. So this is the experience and expertise that we built on in JTN. So what are the objectives for my short presentation here is to discuss with you to what extent it is via the judicial training that we should cultivate integrity, ethics, independence of the members of the judiciary. Is the training the right tool. And right now, I have to stop by the word of training. During our workshops about the principles, we are discussing very much the notion of the training. Some were saying, no, we train plumbers, we train the dogs, we don't train the judges. It is education, it is cultivation, very many other words were used. And at first sight, when you think about the ethics, integrity, indeed, we would like to look for more profound words than the training. But what I'm trying to say is exactly that the training, something very simple, practical, involving, should be the tool to use when addressing the issue of integrity and ethics. Why and how, let's see in a moment. And showing you the example of what the JTN does in this area, I will try in this way to answer how to train on these issues. How to train, not only discuss these issues, not only have them in the principles, but how to train on them. First slide is very basic, I think we all know, we all agree, we all have it in most of the papers for this conference and for very many conferences devoted to judicial training, that we have those three-tier approach to the training of judges. So we have to train them knowledge, not necessarily only the legal one, non-legal as well. We have to develop the skills, everything that is maybe called judgecraft. This is something that, the notion that is quite popular now in Europe, judgecraft. So all the skills that the judges should possess to perform appropriately. And of course, always there is a third element that goes after the other two, which are ethical values, the attitudes. You can find it everywhere, in every paper on judicial training. But then when we look at the offer of training institutes, do we have this balance? Do we have really the equal number of training activities on all these topics? Do we really train a lot on our ethical obligations, ethical expectations towards us, the judges? Do we really have many activities on the attitudes? I leave the answer to you, obviously, but I put this slide again for this presentation, despite it being so obvious. But sometimes I think we have to reflect if we really do what we preach for. We keep saying that we need it, but is it a reality? Or quite opposite, are we very far from that? Then, again, some background rules, principles that are expecting us, judicial training providers, to address these issues. On the screen, you see one of the JTN judicial training principles. This morning, Adele, in the opening session, when she was doing the introduction to the to be adopted IOJT principles, she mentioned that there were several sources to refer to. One of these sources were JTN training principles. We have adopted them in the EU just last year in 2016. One of them, of course, is highlighted. Yes, values should be the subject of the training. Tomorrow, the day after tomorrow, sorry, on Wednesday, we will be adopting our IOJT principles. Again, we will find in these principles this one that you now see on the screen, that we all, as institutions, members of IOJT, commit ourselves that we believe that we should run the training on values, to ethics, and all that follows. So grounds for us are very strong. But then I've witnessed very many discussions on different fora. Everyone agrees that this is a topic to train, but when it comes to be saying, okay, what exactly are we to do with the judges to train them? If we don't want to have the big conferences and discussions recalling to us what the Bangalore principles are, what our national codes of conduct, etc. No, if you want to do a training, something that involves participants, make them work, reflect, be on the workshops, what to do with it, what are the components, what should be the objectives, what methods to use. Here on the screen, of course, I believe most of you recognize it. We all know Bangalore principles of judicial conduct, and these are the principles from the Bangalore principles. We all know them, but how often at our institutes do we reflect how to turn each of them into concrete training activity? What kind of competence we should train, and with which tools, and applying which method, or applying which trainer to develop our impartiality, our integrity. Sometimes I believe we don't even reflect what is behind these beautiful notions that we can see now on the screens. Even more, we should, when designing what we do at the JTN, when designing the training activities, we should really extensively think whom to address with those training activities. Here on the screen you see the 3 different groups that we identified at the JTN, believing that each of them requires a different approach, different tools and different methods when addressing them with the training on ethical issues. At the first stage, of course, the representatives of the senior judicial. Here we mean mainly the members of the councils of judiciaries, those that are there to set the standards for our behavior, those that are there to assess our behavior, those that are involved in different difficult cases about misbehavior of the judges. This is at the end of this round. Then it leads us, of course, to the members of the disciplinary courts, disciplinary panels, however they are structured in different countries. They should be addressed with the training. And then again go through the curricula of all our schools. You can go through in your mind now, through the curriculum of your school, trying to identify how many trainings have you run to the judges of courts or the panels where they are hearing disciplinary proceedings, to make sure that in deciding in such cases of their peer colleagues, they really follow a uniform approach when applying our main principles. But of course, each and every one of us judges should undergo training on that. This is the crucial thing. We were discussing, I was last week at the conference in Taipei, where we were discussing the possibility of having the exit procedures for the judges from the profession. We were discussing, okay, we have a judge that is obviously misperforming, to the extent that it cannot lead to the disciplinary proceeding, but no one is really satisfied from him. What to do with the person? And the conclusion was, there's only one way, to train the person. So each of us, no matter how good we perform, should be subjected to such a training. And I think here is the core. EJTN is trying to identify the most effective training methods and try to see which apply to which topic and how to advise our members, national training providers, what should they do with the often discussed and developed methodologies at the national level. And we came to the conclusion, analyzing the trainings of our members in the area of ethics, that we usually use lectures. Nearly every school is running several years a lecture, inviting very prominent judge, justice, very important person, very important event, then giving the lecture, reminding us what is the ethos of our work, what are the ethical obligations behind. But we believe that's not the way it should go. We believe that the method that should be applied is the method involving participants. We call it participatory training architecture at the JTN. The method that will not only allow participants to hear what the wiser than them have to share with, but really will trigger our reflection, will trigger the process of assessing our own behavior in light of the expected model or pattern of behavior. That will force us to unfreeze some set notions that we keep repeating, but sometimes not reflect what is behind them. And some can say, okay, it's easy to put it in the paper, it's easy to put it on the slide. How to turn it into practice? These are the 3 main training methods that we identified as appropriate for the training activities devoted to the ethical issues. And in a moment I will give you the example of one seminar that we constantly repeat all over the Europe for the mixed audience of the judges from different member states of the European Union. We applied the method based on the problem solving. We give them the issue, put it up on the discussion, and leave them alone, without any moderator, without any wise person around. They have to be there alone, in small groups, feeling safe and being able to disclose what they really think and how they assess their own behavior in the light of what is expected. So problem-solving discussions for the younger judges, for the trainees, is the mentoring. That's why we should have the mentors at the very beginning of our careers. So during this so-called on-job training, when still performing somebody to advise us and assist us with understanding what to do. Of course, when looking at these notions and the methods proposed, we could have a full workshop about such a methodology. There is no room and time for that. I just want to refer you to one of the JTN documents we've produced recently. It's a handbook of judicial training methodology. Here's a link to that. So you can get access if you receive this PowerPoint. This is a book of around 100 pages that is going through all this circle of training, starting with the training needs assessment, preparation, development, evaluation. And for each of these elements in the handbook, we try to explain which methods to use, what are the novelties right now with the concrete examples. I think this is a very useful publication to turn what we talk about into the practice. So I just want to refer you to this document, not giving any more comments on the methods we use. And now the example. We call it European Judgecraft. On this seminar, we run it in different EU member states, as I said, since 2015. Many times every year to different audience, mixed audience from different EU member states. It's an event based on the workshops. And it's a very simple methodology. The workshops, there are small groups of participants that are divided in small groups, no more than 10, it's usually below 10, and they see a short movie, short clip, professionally recorded with the actors, etc. Some real life scenes. And then they are left to discuss. They are left to discuss, to find themselves in the situations that are shown to them on those during those short films, to see what kind of issues, what kind of problems they see. And of course, we have very many movies of this nature. Here you can see just one of the cases described. I know it's too long to read. It's in short, this is the case where the doctor is having a problem with the stomach, coming to the hospital, seeing a crowd of the people waiting since very morning in line to see the doctor, and all of a sudden different doctors passing by, and they chat, and he's the first one to enter. Simple situation. We start with such a case to open the discussions between the judges, our peer to our citizens, or do we believe we are different, better? You can imagine that from such a case, discussion might go very different directions. So it's not a case having good or bad answer. It's not a case that should limit itself in a given area of the rules, the ontological rules. No. This case is leading our participants to very many different directions. It cannot be foreseen. But this is the way that we believe is the only one to make them think, okay, I did it last week when I was in my doctor. And there are very many different life scenarios from the court, from the private life, that allows us to trigger such a discussions and to find ourselves in different situations. And this approach proves to be very effective. My last slide in a moment will be mentioning some ideas what we should do in the international context to enhance efficient training activities in the area. I have to tell you that this is exactly the example of the international cooperation on the training activity. EJTN is not the source of all the wisdom. We base our experience on the experience of our members. This approach was taken from UK. The College of England and Wales was running such a training activity for some years. We were running a project identifying best practices in different areas in EU. That was one of them identified. So we took it to EJTN, and our aim is to address those that we call multipliers. So the trainers, the people from the national schools, to involve them, to show them how to run it, hoping that it will be followed by the national training activities. So this is a kind of sharing expertise between ourselves. I believe that IOJT should be a forum where we can, this way, as we do it within the EU, share the expertise in worldwide dimension. Of course, there's always a room, especially on the topics like ethics, deontology, to deliver international training activities. There we share the same values. And of course, whatever we do at the higher than national forum helps us to develop what we are obliged to develop at the national level. I exceeded my time? I hope not. Thank you very much for your attention.
Judge Postolski's been working all day today. I think you probably noticed. Also, next, Chancellor Escuna is going to talk about some of the regional activity in relation to the topic of ethics and values. So, Justice Escuna, thank you.
Thank you, Mr. Chairman. Honorable participants and colleagues, good afternoon. I shall report on a roundtable discussion which was held last August 29 to 30 here in Manila, sponsored by the Konrad Adenauer Stiftung, on the subject of judicial ethics, integrity, and accountability. A number of Asian countries were represented in addition to the Philippines. Germany, of course, was also represented. We had Cambodia, Indonesia, Taiwan, among others, Malaysia. And it started with a Skype presentation from a fellow named Diego Garcia Sayan, who is the UN Special Rapporteur on the independence of judges and lawyers. He was supposed to come for the roundtable discussion, but that big storm hit Texas and canceled his flight. So we hooked him up by Skype, and he addressed the conference to first explain his duties as rapporteur, which is to act on human rights concerns, individual or institutional, and to visit the countries that officially invite him and prepare studies and reports. For the conference, he identified a key safeguard or for independence of the judiciary. Two safeguards. One is the criteria for selection of judges. Selection, appointment, and promotion of judges should be done by an independent authority, with members composed largely of judges. The second is funding. Adequate funding for the judiciary and financial security for individual judges. These are the two key elements to assure independence of the judiciary, as far as the UN rapporteur is concerned. I opened the conference and also cited the two main problems in the Philippines facing the judiciary: court delay and corruption. So the topic of integrity was very relevant. The different delegates, starting with Myanmar, in turn spoke about judicial integrity and corruption in their countries. Mr. Unyinyi from Myanmar stated that the constitutional tribunal of his country is still in its early stages and with limited experience, and therefore he was very happy to attend the conference and listen to the other delegates. He said that in their country, and this disarmed us, because he very frankly said that their constitutional law was drafted by the military regime, and the tribunal itself is very much dependent on the military, and therefore they have still a lot more to develop in the march towards real democracy. It's very courageous of Mr. Justice Unyinyi to speak out against their own system by saying that there is still a need for them to wean themselves from the military as far as the judicial independence is concerned. The next speaker was Dato Param Kumaraswamy, who is from Malaysia, but he was also a former UN rapporteur, and he participated in the adoption of the Bangalore Principles, together with our former Chief Justice Hilario Davido, Jr. And he named the 6 values on which the principles were mixed: independence, impartiality, integrity, propriety, equality, competence, and diligence. But he stressed the need for monitoring and an enforcement mechanism, including a formal judicial complaints mechanism. Dr. Kumaraswamy cited the American Bar Association model for judicial conduct, for code of judicial conduct, which requires judges to take action when they know of a colleague who has violated the code of ethics. Next was Dr. Chen Shen-min from Taiwan, who was Chief Judge of the Judicial Yuan, which is the Supreme Court of Taiwan, was now retired and teaches in an academy. He said there was an attempt to undertake judicial reform in Taiwan, but it was undertaken by mostly non-legal actors, non-legal participants, and it did not succeed because many of them did not understand what the problem was. But he said lately there has been a positive development in the adoption of the Judges Act of 2010, which adopted many of the Bangalore principles. For our part, we presented Justice Hilarion Aquino, who is our expert on judicial ethics, and he highlighted that the Philippines is the first constitutional democracy in Asia, and its judiciary enjoys judicial independence. But he presented the challenges facing the independence of the judiciary. Corruption, which he tags as the antithesis of integrity, remains a pernicious malady in our judiciary. Justice Aquino enumerated dismissals of judges by the Supreme Court. Judges found guilty of various corrupt practices, and he stressed that some lawyers are to be blamed for instigating corruption. The relationship of the judiciary to media was taken up by Justice Aquino, and he recognized the need for a balancing between confidentiality of proceedings on one hand and the right to information of public interest on the other. So he counseled very wisely that judges should learn to live with critical media, and media should learn to respect the sensitive nature of judicial proceedings. Then followed Justice Maria Filomena Singh of the Court of Appeals, who stated that judges are socio-cultural beings. They do not decide cases in a vacuum. They decide it in a social context. And in the Philippines, the social context extends to a lot of values that could affect the integrity of a judge, such as what we call utang na loob, which is translated as a debt of gratitude. The judge sometimes is impelled by a sense of gratitude to decide a case in a manner that is not impartial. Pakikisama, which is a culture of hospitality, is another value that could affect independence and impartiality. So there is a need to reckon with the social values and the social context of judging. From Malaysia, Dato' Ma Weng Kwai, who is a member of the Judicial Appointments Commission, also treated of the problem of corruption in Malaysia. And he said that the good news is that the delay, as far as the delay is concerned, was addressed successfully in Malaysia by creating new courts that would handle new cases. So the old courts would handle the old cases, and the new courts would handle new cases. And this system worked and reduced their number of cases pending in Malaysia. An interesting speaker followed, and this is a fellow named Professor Sharif Laude from Indonesia. He heads the Indonesian Anti-Corruption Commission, or KPK, which was awarded by the Philippine Ramon Magsaysay Foundation, a special award in 2010 for exemplary work done in the field of justice. And while he was speaking, he was called a very urgent message, and he had to leave. I think one of his colleagues was either shot or killed. It's not dangerous, his work. But before he left, he shared with us certain aspects which we did not know. For instance, I asked him, what is this, they call it anti-corruption fiesta. You know, fiesta is celebration. Why do you have fiestas for anti-corruption? He said, you know, we just don't go after corrupt officials. We go after the roots. So we celebrate, we hold celebrations or fiestas and invite wives of officials and their families, and try to cultivate a culture of integrity among the families of officials. So that was a very eye-opening thing for us. But I know the record of this organization. They have successfully prosecuted even justices of their Supreme Court. So they said they are the most hated by officials, but the most loved by the people. So very much praise for this institution in Indonesia, Anti-Corruption Commission. From Cambodia, we had a Professor Taing Ratana, who traced the relationship of their justice system to their religious beliefs. And they believe that their religious or their God is the guarantor, together with the king, of the independence of the judiciary. And the king, as guarantor of the independence of the judiciary, created the Supreme Council of Magistracy, which assists him in his tasks. The role is to submit to the king requests for appointments, transfer, promotion, discharge, suspension, and removal of judges, and to mete out sanctions to the judiciary without the Minister of Justice taking part, to maintain separation of powers. And finally, we were made aware of the challenges facing Cambodia for successful judicial reform, how it needs time, resources, human resources in particular, and he hopes that a new generation of educated Cambodians will one day guarantee social order and peace in his country. Justice Sinaida Lagiles of the Philippines then presented another side of judicial independence in the Philippines, discussing the constitutional provisions that are designed to protect the independence of the judiciary. In our constitution, the budget for the judiciary is treated in a special way. It cannot be reduced by Congress once it is fixed for a particular year. And once it's appropriated, it has to be released. The control of the budget is one of the most effective powers of the president. I know because I work for a president. And we call that the gripo. The gripo is the faucet. And the president can control the flow of the water to the faucet. Even if Congress has already appropriated the funds, you still have to go to the president for the release of the funds. But in the case of the judiciary, because of a provision in the Constitution, once Congress appropriates the funds, it has to be released automatically by the president. So that removes the leverage of the president via the budget as vis-a-vis the judiciary. The problem is the amount of the funding, because Congress is prohibited from decreasing it. What Congress does is they do not increase it. So they are not prohibited, they are not mandated to increase it. They are only prohibited from reducing it. So for over 10 years now, the budget of the judiciary has consistently been less than 1% of the national budget. The entire judiciary, not just the Supreme Court, less than 1%. And so the judiciary has to make up for the lack of the funding through savings. So we maintain a vacancy rate of about 25%, used to be even 35%, in order to have savings, in order to be able to run the rest of the judiciary. So this is a particular problem in Philippine judicial system. The relationship between Congress and the judiciary as far as the budget is concerned. There has to be some dynamics. For instance, one way is to create a special type of fund that is not considered as counted among the items they cannot reduce. Special capital funds, for instance, just to construct courtrooms. They don't have to enact that every year. Just one-time funding to replace all the old courtrooms. And that is being discussed. That could be a possible way out of the dilemma. We had other speakers from the Philippines. Justice Bruselas dwelt on the Code of Conduct, and Justice Romeo Callejo Sr., who is the Vice Chancellor of Philippine Judicial Academy, treated of judicial accountability. He is one of our experts on judicial accountability, and he proposed a permanent body that would investigate corruption in the judiciary. Right now, it's treated on an ad hoc basis. Every time there's a complaint for corruption, the Supreme Court forms an investigation body to look into it. And because under our Constitution, it is only the Supreme Court and bank, not even one of its divisions, that can remove a judge. So before it does that, of course, it has to investigate the complaint, and there is no permanent body to do so. It's always done on an ad hoc basis, and that is cumbersome. The Philippine Supreme Court spokesperson, Attorney Theodore Te, who is attending this conference, gave a report or presentation on the judiciary and media. The relationship of the judiciary and media is very critical and sensitive in the Philippines as elsewhere. And we do regulate to what extent media can cover court proceedings, especially sensational court proceedings. We do not allow, for instance, television coverage in public hearings of the Supreme Court. They are allowed at the initial opening of the proceedings, then they are asked to politely leave and watch from outside. There is a screen that would show through the court's own indoor television system what is going on, and they can hook up to them. The court administrator was also attending this conference. Midas Marquez presented his own evaluation of the problems facing judges. He is the one who gets all the complaints from the judges, whatever they lack, and he goes around the country in order to get all these feedbacks from them, mostly resources, courtroom, how to improve supplies, courtroom, and so forth. So that is Midas Marquez. So in general, the conference was very successful in that it consisted of a regional sharing of best practices as well as problems with respect to judicial ethics, integrity, and accountability. Thank you.
Thank you, Your Honor. Chief Justice O'Connor, are you going to?
Yes.
Okay.
think I'll change things up a little and speak from my laptop that's here, because it's just going to be a lot easier for me to refer to my notes as I go along. So, good afternoon, everyone. It's a pleasure for me to be here. I thank you for the invitation. I'm going to talk a little bit about accountability and both institutional and individual integrity. And I think that from our perspective, at least in the U.S., there's three things that are needed in order to ensure individual and institutional integrity, and that's the right judges, the right education, and the right environment. I think that we start with the premise, and I think this is integral to the concept of the rule of law, is that government is the servant of the people, not its master, and that is somewhat of a novel concept in jurisdictions, even in the United States. It's novel with many of the justices and the judges, as you, depending on where they've come from, what their education, and certainly what their experience has been. The role of the judge is to be a public servant to the public, and public service requires competency, transparency, and accountability. Public service, again, accountability, integrity principles. And the vision in the service of the public, a judge's mission is to administer justice fairly and impartially with the utmost integrity and to provide support for the judicial branch as an institution. So it is not merely about the individual judge and how that judge operates or performs his or her duties. It's about the judge's place within the institution of the judiciary that has to be contemplated as well. Respect for the judicial branch or the institution is the protector of the rule of law is essential, because there is no other protector of the rule of law, at least in our country, except for the judiciary. So it starts with each individual judge. The institution, but certainly the judicial institution in the eyes of the public are its judges. An incompetent judge diminishes the entire branch. A corrupt judge corrupts the entire branch, and a lazy judge reflects on all judges. You know, very many people, most people in our country do not have an experience with a judge. They do not come to court because they have no criminal proceedings, and if they're lucky, they will have no civil proceedings that will bring them into court. When I say that, I mean, for the most part, although divorce is very much prevalent in the United States, and if people will have a contact with the court, it will be in the context of a domestic relations case where they will have a divorce or a traffic ticket in another court. But outside of that, there's very little contact by the average citizen with the courts. So their perception of the judiciary is framed by their perception oftentimes of one judge that may make a headline or make a news story or show up on the evening news, and that taints the entire integrity of the branch. And that's why it's important for each judge to assume that responsibility, that they're not only representing themselves, but they're representing the entire institution of the judiciary. Now, each method of selecting judges presents some issues on its own. How do you ensure that you have the best people for the judiciary? The selection of the right men and women to become judges varies within jurisdictions in our country. Jurisdiction to jurisdiction, state to state. We have 50 states, we have 4 territories that, and we also have the overarching federal system. They're selected in a variety of different ways. In our federal system, judges are appointed by the president, they are approved by the Senate, and then they retain their position for life. The only way that they can leave is voluntarily through retirement. Oftentimes they don't retire, they just take senior status, and they hear a diminished number of cases, or they could be impeached, but again, that impeachment, that removal process, again, is very complicated and doesn't happen very often on the federal level. The state level, depending on how they are selected, will dictate how long they serve, and how they are removed for cause from office. We have opportunities to select judges by election, by retention election, by appointment of an executive branch, and how they stay in office is different as well. If you have an elected judge, as we do in my state, I'm an elected judge. I am on the ballot every 6 years, and the entire voting public of my state elects the judge. They vote on the judge. They do that for me as Chief Justice, and they do it for every other judge in the state, all the way down to the lowest courts that we have in our state, our municipal courts. In other states, the jurisdiction would be that they are appointed as a judge through either appointed by the governor, or appointed by a council, appointed in some jurisdictions, judges are appointed by the legislature. And then they have to have retention elections after so many years. Oftentimes it's after 2 years, and the public will vote on whether or not they're satisfied with that member of the judiciary. So it's not where the judge is being challenged by another person that wants to be a judge. They're being challenged by their record. Their record is reviewed, and the retention is based on their record. And then, of course, we have other jurisdictions where judges, as I said, are appointed for life. We have some state courts where once you are appointed, you serve until you reach a certain age. We have some jurisdictions that have no age limit. We have other jurisdictions that have the age of 90. You can't be a judge after 90. In my state, you can't be a judge, you cannot run for election if you are 70 years of age. There's others varying 75, but 70, it varies, it runs the gambit, but there is no uniformity, that's what I'm saying, across the country as to how and when you leave the bench. So each method of selecting judges presents its own challenge. If the method of election is used, you have to think, will the judge be political in his or her performance on the bench? Will those in the political minority be disadvantaged because they are not being, quote, represented by a judge from their minority? I guess, perspective that I operate under is that a judge has no constituency. When they run for political office, they have no constituency. It's not as though they have to be beholden to any political party, one political party or another, and they should not be swayed by the will of the people. The will of the people gets them elected, but that's as far as they need to consider the will of the people. That's a foreign concept to many judges, and even in the United States, some judges don't understand that. If a judge is selected because he or she pursued an educational curriculum, and that's how they became a judge in some jurisdictions, some countries, that is the method. You start wanting to be a judge, you take the education to be a judge, you take testing to be a judge, and then you are appointed a member of the judiciary. Oftentimes the concern in those instances is there enough real-life experience? Has this individual been involved in the legal system, in the court system, with life's experiences in order to be able to supplement that curriculum that they have studied in order to make wise and reasoned decisions? So that seems to be an issue in some jurisdictions. And finally, if a judge is appointed by an executive or a council, will there be the requisite judicial independence in decision-making? This is especially true when the judge is subject to reappointment in order to keep their job. I mean, it's one thing to be appointed, but I guess the consequences of being appointed and then the desire to be retained during that period of time, will the judge take into consideration what the appointing authority would like to see in that judge in order to secure retention? That can be, somewhat problematic. Will they, again, maintain the requisite judicial independence? This is true when the judge is subject to reappointment, and it's not such a concern if the appointment is for life, obviously, and that's in our federal system. That even if the members of our federal government would be disappointed in the decisions that are made by our judiciary, our federal judiciary, they have no choice but to obey them. It is not a choice that they have. So the problem, though, with these life appointments becomes the lack of accountability as a public servant. And that does not have to do with their decisions that they make as a judge on cases that they're making, but their decisions that they make or their choices they make in other areas of their existence, which often can reflect poorly on themselves and the judiciary. So the vision, how is it to be realized then? The vision, the various methods of becoming a judge enhances the overarching truism that education is the means to achieve this vision. With all the different methods we have of selecting judges, there has to be a continuity of vision, no matter what that selection process is, and that vision will ensure continuity and adherence to the principles. The purpose of judicial education is to serve the public interest that mandates that there's competent performance of duties, that there's accountability of the judicial officer in their operation. Judicial education's role is enhancing integrity and accountability. Compliance with the rules, including mandatory judicial education. And that seems to be the most important method of ensuring that the vision is met and that judges are compliant with that vision, is to have mandatory judicial education. We have mandatory judicial education in my state, and every 2 years you have to report to the Supreme Court that you have complied with that mandatory judicial education. And if you don't, you can be removed from your bench. You can be removed as a judge if you do not comply with your mandatory judicial education. That's an extremely experienced. By the same token, lawyers have education, mandatory continuing legal education, and if they don't comply, the Supreme Court can remove from the ability, or take from them the ability to practice law. So we take our continuing legal education extremely seriously in my state. There's other states that do as well. And then, believe it or not, there are some states that have no mandatory education for their judges or for their lawyers. It just, again, varies by jurisdiction, state to state. So you have the right person, hopefully. You have that person that is taking the right education. So what is the right education? It's the focus on the judicial conduct education. It's not so much a focus on the competency, knowing the law. Because as I always say, that's why I have law clerks. That I can, rely on my many law clerks when I want to know, what the law is. They certainly would research it at a moment's notice. I have that obviously in advance of the cases that I'm hearing. It's not that I have the ability to call them to the bench and say, research this and come back in 5 minutes. But we have the competency, the core competency of knowing the law is not what I'm talking about here. I'm talking about the ability to focus on your judicial conduct education. And that has to be designed to meet the varied needs of all judges. Judges early in their career, in their mid-career, and then at the end of their careers, or on their way, to retirement. And it's jurisdictional specific. Education for all judges, and that means ethics, professionalism, access and fairness, technology, court and personal security, case management, administration, and operational duties. It runs the gambit. Education must be more than knowledge-based. Knowing the law and the rules of evidence, of course, are important. And skills, such as trial skills, how you conduct yourself on the bench, and especially in front of a jury, is extremely important. When the public is asked to describe a good judge, however, typically the qualities they mention address attitude, professionalism, and integrity. Thus, judicial education typically includes education on attitudes, a judge's thinking and philosophy, on ethics, on professionalism, and integrity. The public expects a judge to be knowledgeable in the law. They expect a judge to be able to reason, research, and apply. But these other areas are extremely important that they expect as well. So, how do we develop content for the education that is so important to the judiciary? And the way we do that is through judges developing the content along with lawyers, along with educators. It has to be a collaborative effort. The thought of judges, only judges, educating other judges, I think falls short of the mark, because I think that the independent observation is not there. The assessment qualities and abilities is not there. I think that we have to have judges, we have to have lawyers, both prosecutors and defense attorneys, and we have to have judges themselves. And I see Jeff is signaling. Am I out of time?
Just a signal.
Is a signal?
1 minute.
All right, 1 minute. Okay, I've had so much more here that I hope will come out in the questions. So there must be a curriculum tailored to the type of judge and the judge's length in office. I'm going to skip down here. Well, the right environment. Let me just close by saying you have to have the right judge, you have to have the right education, you have to have the right environment. The right environment means that you're partnering with your other government entities. You're not just relying on judges speaking to one another in an echo chamber. So you're not, you have to pull in your partners from the legislature, from the executive branch, and they have to be educated along with the judiciary in order to allow for these principles, the following of the rule of law, the accountability, the objectivity, the access. Those are all issues that other branches of government can and must participate in as well. They have to be on the same wavelength as the judges are in their thought processes. Judges have the ability to issue an order, and in a country where the rule of law is respected, it may be grumbled about, but it is adhered to. But you want more than that. You want buy-in. You want the other institutions of your government to embrace what the judiciary is trying to do, and that's why it's critical that you have conferences, not just with judges to judges to judges. You have to have conferences and envelop the other leaders of government in order for them to give you that buy-in that will allow you then to do the job, to have the accountability, the integrity, and the public respect for the institution. With that, I'll close.
Thanks. Now we have Ms. Solis, who's going to talk to us a little bit about her project and some of the more specific tools, sets and kits that they're working on at the United Nations Office for Drugs and Crimes. So Roberta, I'll turn, you have a PowerPoint, you got it ready to go? Okay.
Thank you, Jeff. Good afternoon, everyone. First, thanks to the IOGT, to Jeff, and to the Philippines Judicial Academy for the invitation to be here and to open up the space for us to present on this new initiative by the United Nations Office on Drugs and Crime. This initiative, the Global Judicial Integrity Network, is part of a global program that was launched by UNODC in 2016 to help states parties with the implementation of the Doha Declaration, which was a political document adopted by member states of the UN at the end of the last United Nations Congress on Crime Prevention and Criminal Justice held in Qatar. And in this document, among other commitments, member states committed to prevent and counter corruption, enhance transparency in public administration, and promote integrity and accountability in the criminal justice system. So UNODC launched this global program to assist with these four areas of the Doha Declaration. The one I work on as the team leader is judicial integrity, and in this component of this global program is where we are developing the work of the Global Judicial Integrity Network. But this program also works with three other areas, with education for justice, developing curricula for all levels of education, so teachers can work with students at all levels on issues related to crime prevention, all crimes, not only corruption. The prevention of youth crime through sports, and the rehabilitation of prisoners are the other areas of this program. For the Global Judicial Integrity Network, one important and key information is that UNODC is the Secretariat for the United Nations Convention Against Corruption, which is the only globally legally binding document against corruption. The convention was adopted in 2003, and it's a benchmark in the fight against corruption because it divides the work in all the phases or all the areas of combating corruption, from preventive measures to asset recovery. And in the chapter on preventive measures, we have Article 11, which is the article of interest for us here, and the basis for UNODC's work in judicial integrity in the last 15 years. Article 11 demands that states parties adopt measures to promote integrity and prevent opportunities for corruption within the judicial system, bearing in mind the necessary independence of the judiciary. And Article 11 is also applied to prosecutors in those countries where the prosecution services have the same level of independence as the judiciary. So in the idea of creating a global judicial integrity network is to help judiciaries in promoting judicial integrity and preventing corruption within the judicial system as a way to make sure and enable the judges to perform the valuable role that they have in the fight against corruption. So they have the necessary structure and mechanisms and tools within the judiciary to undertake this important role. With the network, we aim to create a platform to connect the judges around the world so they can learn from each other and they can have access to different resources, tools, and materials that will help them in promoting judicial integrity. And we aim to do that through network meetings, international and regional meetings, virtual meetings, the creation of working groups on specific issues. We also aim to do that by creating a database of resources. We are developing a website that we plan to be a one-stop shop for all the resource material on judicial integrity. So this library of resources will be a good point of departure for anyone that wants to find more information in the different areas of judicial integrity that will support not only their day-to-day activities, but also reforms that jurisdictions decide to undertake to improve judicial integrity and prevention of corruption. In developing this library of resources, we are also going through a scoping exercise to identify what resources are available, not only UN resources, but the resources that have been developed by other institutions like the IOJT, the EJTN, and other institutes, NGOs, the academia, and other organizations that have been doing a lot of work in judicial integrity. The idea of the network is also to be a place where we can connect all of these existing initiatives at the regional, local, or even in the international level, so we can maximize the impact of what is already out there, connect those, and create new synergies in our work in preventing corruption. And in developing tools for integrity, one of the areas that we'll be working on, for example, is one area that we have identified that there is a gap in existing guidance, which is the area of the use of social media by judges, which has been identified in the various outreach activities we are conducting to create the network as one topic of interest by judges, and how this could impact impartiality, independence, and even propriety, 3 of the 6 Bangalore principles of judicial conduct. And another area that we are working on is judicial education, but I'll come back to that later. As I mentioned, the idea is also to provide assistance to the judiciaries, technical assistance based on the needs that the judiciaries identify themselves as needs they have to improve judicial integrity and prevent corruption in their judicial systems. And this technical assistance can undertake various forms as legislative assistance with legislative drafting, policy development, capacity building, and any other forms that the jurisdictions identify. As I mentioned, in order to create the network, we're going through extensive outreach to judiciaries, individual judges, and judicial associations, forums, institutes, and any other organizations that have been conducting activities in judicial integrity. In the case of the judiciaries, we've been conducting regional preparatory meetings for the launch of the network that gather chief justices and presidents of Supreme Courts to discuss how the network can develop tools that will be useful and adequate to help them with these challenges, and also their inputs and comments and suggestions as to how the network should be structured and created. We've organized last year meetings for Latin America and Southeast Asia and the Pacific. This year we've organized meetings for Europe and for Francophone African countries, and another meeting for Anglophone and Portuguese-speaking countries in Africa. And Jeff participated in our meeting for the Anglophone and Portuguese-speaking countries in Namibia. And with that, we have concluded this series of regional preparatory meetings, which will then be the basis for the launch of the network next year, which is planned for April 9 and 10 in Vienna. And I leave here the invitation to all of you to stay tuned for that and participate through any means that will be available for that. But not only we've been discussing with the Chief Justices, but we are also reaching out to individual judges, to the heads of the training institutes, to the heads of the disciplinary bodies in the judiciaries, and we're doing that through the meetings of the judicial associations and forums like the IOJT and other associations that you all might be a part of. I know that there's someone here who was at the Commonwealth Magistrates and Judges Association a while ago, in which we also participated to talk about the network. And as we can't be in all the meetings throughout the world, we're also conducting an online survey, which is open to any judge to participate. The survey is available in various languages to also facilitate participation, and I encourage all of you to take part in that. I'll have the link in a minute. But other priorities, as I mentioned, a big part of the work of the network will be the development of new guidance and new tools for the judiciaries. And in that sense, we've already started the work of developing a judicial ethics training package for standing, but most importantly for newly appointed judges. And this training package is based on the Bangalore principles of judicial conduct, mainly in the commentary to the Bangalore principles and on the implementation of Article 11 of the UN Convention Against Corruption. For the development of these tools, we've organized an expert group meeting last August in Vienna, and we had also some of the members of the IOJT here participate in that meeting and provide us with very useful and important insights as to how to make this training package really meaningful, adequate, and really tailored to the needs of the judicial training institutes. We have 9 jurisdictions that have agreed to be pilot sites for the implementation of these tools. And we'll be working with them also in the development. So they are directly working with us in providing comments and feedback as we are developing these tools. And the 2 tools will be an e-learning course and a manual, a guiding material for in-person workshops, one-day in-person workshops. So it's a teacher's manual on how to organize such trainings. We plan to have the beta version of the online tool available in April for the launch of the network. I also encourage other jurisdictions here present that have an interest in judicial ethics training to contact us to learn more about the tool and see if it's adequate to your needs. If it's not, we can also work with you to adjust that. So because the idea is that this is a package that each judiciary can adjust to their own circumstances, cultural differences, their needs, and also to incorporate, especially in the in-person training, the training that you might already have on your own national regulations and standards for judicial conduct and ethics. And as we develop the network, what we want really is to hear from you how you want this network to work for you. As I mentioned before, this is a platform for judges to connect with each other. It's not a platform for UNODC to tell you how to improve your judiciary, but for you to tell us what needs you have to do so, and so we can look for the resources that will help you achieve those goals, either through the technical expertise we already have in-house, or putting you in contact with your peers, with other judiciaries, or even working with you to develop the new resources that will help you achieve those goals. And here you can find the link for the survey, but I guess it's not very easy to read in this color, sorry for that, but the presentation will be available for the organization of the meeting, and I'm also available after the session in case you need more information. But do participate on that, and let us know of your needs, your expectations, and how you think that the network could be working for you. Just to give you, and to wrap up, some information about the results of the survey so far. We've had almost 500 participants so far since September when we started the survey. Around 58% of those participants are also involved in the training of judges. Around 40% of those respondents to the survey identified insufficient training opportunities on ethics and anti-corruption as challenges to upholding integrity and preventing corruption. And over 56%, on the other hand, identified that their judiciaries have been adopting measures related to training of judges as a way to promote judicial integrity and counter corruption. So you can see that judicial training, it is one of the main components of a wide framework to promote integrity and prevent corruption. So I encourage you to participate and add to those numbers and add your experience with judicial training and how this can be used in the wider framework of promoting integrity and preventing corruption in the judicial system. So thank you so much for your attention, and you're all invited to be part of this network, make it yours, and make your voices heard, and tell us how you want us to work for you to that sense.
Thank you very much. Thank you. 4 great speakers, different topics within the field that we wanted to discuss. We have a few minutes left for some questions and observations. I've had the opportunity to work with all 4 of these people in different capacities in the evolution of training on the principles of judicial conduct and integrity. Something I managed federal courts for 30 years, the disciplinary process, United Nations Yugoslavia Tribunal. Really, it boils down to me to one simple concept. Integrity in fair and timely decisions is our greatest defense as an institution. We don't have many defense tools. We're not political, we're apolitical, so we have to be the best we can be. And I know from my travels that our ability to reinforce those defense mechanisms, I believe, is critical to our institution's success and survival. Now, I want to, with the panel here, I just wanted to mention that because this is integrity is very close to all of us. And we've talked about the global network, which I think is going to be an excellent tool. The National Center for State Courts has a resource center that I know eventually will be connected, which includes many tools. Also, I was going to ask a question. How many countries test judges on selection for ethics? Does anybody have ethics examinations during their selection process? I did not know. You do. Can you tell us a little bit about how that works, sir? Yeah.
So my name is Barry Clark, I'm from England and Wales, and the Judicial Appointments Commission recruits by reference to certain criteria, one of which is fairness, principle of dealing with people, communication skills, but the ethics part can be tested on a computer sift in order to reduce the number of candidates for interview by setting before the candidates a tricky situation. Might be an ethical dilemma, it might be an issue arising in court about possible bias and how they might deal with it, and they're graded according to their answers, and that feeds into the mark they get as to whether they get through the sift to the interview at the next stage.
Okay, thank you, thank you. It's something that I've noticed as I travel the world, that this examination phase is being considered in the screening process. How do we teach judgment? How do we teach conscience? How do we teach judges that in the gut, when they know in their heart something's wrong, to ask the question, what do you think? It's basic. Now, we have so many distinguished people in this audience. Does anybody have a comment or a question for the panel? We have about 10 minutes about how you approach your training in your countries regarding ethics. Any practices you think you would like to share? Any? Yes. I'm used to hanging out microphones. So.
I think Justice O'Connor mentioned the mandatory judicial education hours in her state, and I had a discussion with Judge Wojak this morning about trying to encourage countries and institutions to have mandatory training. He said it was somewhat controversial. But in my state, of the 45 hours that are required for continuing education, a certain number, I think it's 10 out of the 45, have to be devoted specifically to ethics.
Okay.
So on an ongoing basis, a percentage of the continuing education has to have an ethical component. So we present our conferences, we always have specific topics dedicated to an ethical topic.
Thank you.
I might add that we have about 59% of our judicial courses. We have a judicial college in Ohio, and there's a mandatory number of hours, again, that have to go towards professionalism, ethics, that sort of thing. But when you look at all of the types of various courses, even the content courses that are not necessarily a conduct course, woven into all those courses, there's about 59 to 60% of our courses also have a judicial conduct component in those courses. So you get the black letter law, you get the application of that, and you get the ethics and the conduct as well.
Just a comment from England and Wales. We have a cross-jurisdictional course as part of continuous training. It's not mandatory. Judges elect to go on it, but they're shown a DVD containing actors in a scenario. It's called Judging G's. So one of the judges is dealing with an issue where his spouse wants him to get involved in a political campaign, help with organising and demonstrations. Another one involves a cleaner who is not in the country lawfully. And the third scenario involves an appellant in a case handing over to the judge some embarrassing stuff they found out about them on Facebook. And then all the delegates split into small groups to discuss how they would deal with these scenarios. And because it's part of continuation training, in an effort to make it, to expand it, it's now going to be part of induction training using the same materials. So I thought that might be useful to share.
Yeah, thank you. Thank you. Yes, just a second. Now we have, we're going to hear first judge and then here.
I just wanted to share that in Pakistan, the Federal Judicial Academy, we are dedicating, it's not really well calculated, but my guess is that we're doing about 10 to 15% of annual trainings. We are integrating, and we have introduced ethics for judicial officers as well as for the court personnel, because they go hand in glove, and it's very important that the court officials and personnel, we try to focus more on them as well, because they're the ones who are dealing with the public more. And then the judicial officers are there, so we're not really sure who's, there's a blame game or not. Having said that, for both, we have introduced you that, and we would like to intensify that training in the given process.
Well, thank you very much. I thought something Judge Pistolsky said, thought was really important, is training presidents about how to manage conduct and integrity in their courts. And I noticed that, and I thought that was a really important comment.
Thank you, sir. Just two things. I am all for on the mandatory training, this thing, but the people who will decide about mandatory trainings are the ones who do not want that, the senior judges. So how do we sort of go convincing them? And two, we mentioned, films were mentioned regarding ethical issues. Can we have access to these films for use in our academy? Because we may not have the resources to make our own films on these ethical issues.
So we have a question on motivation, I think. Who would like to respond to his first? Would you like to try?
For the motivation, of course, we observe in Europe the process that more and more member states introduce obligatory training. But we rather do not generally believe that this is the way. We have such a body like Consultative Council of European Judges. And many years ago, they published a paper on judicial training, and they said it's the quality of the training what should attract judges to take part, not its obligatory status. So I think the way it might sound far from our on the grassroots level daily work, but the way to go is to try to influence this culture in the judiciary, that we should start to see the training as a must in our daily duties. Of course, the higher we go in the structure, it's more difficult to introduce such an approach. That's why we have to really start working on the most senior judges and start from there to try to change the mindset, seeing that no, training is not something extra on top that will disturb our daily work, quite opposite. And we are far from, at least in Europe, we are far from achieving the goal. But we do many things to address those seniors. Just to give you the example, at the JTN we ran the exchange for the presidents of courts to keep sending them between member states to show, making the training activity and to show them how such training activity can help them in management. Just a simple case. But with a collection of such tools, we can slowly but surely start changing the culture, making the training be a real part of our professional lives. That's the only way. Any provisions, any obligations, I don't think will solve it. They will not change our mindsets.
Yeah, very good. Yeah, Chief Justice O'Connor.
I agree that you have to make it valuable to them. You can't just make the order and say you have to do this. You have to have the right institutions in order to do it. Our judicial college is in Ohio is the institution that comes up with the courses, etc. The bar associations also provide courses that judges can take and lawyers take. It's continuing legal education for all members of the profession, but if you make it a worthwhile commodity for them, and sometimes you might start out with it being just being voluntary and not mandatory, but you really have to focus on the quality, and then the method of delivery is extremely important. You know, for a while it was you got to do it in person. Judges have to leave their jurisdictions and come to a central place and listen to lectures, and that's a horrible model. That's a horrible model. If you can make it, as we've heard here, more interactive, make it hands-on, make it discussions. We have the technology that you don't have to be in the same room with the people that you're communicating with. Make these webinars or online experiences and take advantage of the technology. Make it as painless as possible and only have the hours recorded that they have taken without testing. I'm not advocating that they're going to take continuing legal education, then there's going to be a test at every course they take. We don't have any of that. We don't have testing. We just have quality content that is oftentimes, made available to the judges. So there is no reason not to, quite frankly.
Thank you, Your Honor. One more question, and then we're going to conclude. Yes, ma'am. I'll give you the mic here. Or observation.
Yes. First of all, let me just say that from the orientation career development program, we have ethics as a compulsory course. In the Philippines, we have a mandatory continuing education, and every 3 years they have to comply with such an requirement, and they have to put in their pleadings with lawyers that they attended a mandatory course, and of course we said non-compliance of all the lawyers. We have 69,120 lawyers that we sent to only recently. And of course, a pile of letters that came back of not complying with MCLE. Now, we have a special course in a module which we created first by UNDP, because I was one who made the module together with 2 others, and we applied it first to the office of the court administrator to see whether, because if they're going to get complaints, they must know exactly what the complaints were. And second, we have, whenever we have appointments for vice executive judges and executive judges, and we have a manual for that, usually we have a seminar, and we go around the country for that. And of course, once the appointment is made by the Supreme Court, we start that. The module consists of, shall we say, not lectures, but caselets. And of course, I started because I always say, what are the sins of judges? And I give them all the disciplinary methods. Of course, ignorance of the law is the one that is the most prevalent. And of course, I say, why? We have PILJA already training you to be ethical. And you know what my conclusion and the rest said? 1, did not listen to the lecture while attending a seminar. 2, just plain lazy. And 3, he's corrupt.
Thank you. Thank you, Mayor. Appreciate that. Good comment to end on. I wanted to say thanks to all of you for being here. And we have a gala, we have a culture night tonight at 7 o'clock. But I think it's also very important, if anybody has your card that you want to give to Roberta, it's really a good opportunity for the globe to work together on judicial ethics. So she's here for you. She's going back tonight, so this is probably your last chance to get with Roberta. And I really look forward to the April conference. I also wanted to say also about, I thought Chancellor Escuna's presentation was very important, because I've been in 4 meetings in the last 2 months on the development of global principles. Transparency, public trust, ethics, accountability. There's a trend right now that's ongoing globally, and I think it's really important for us to invest our time with the United Nations to collectively develop practice, as well as IOJT and any other NGO. So we're really happy she's here. I was really happy Justice Acuna's experience with the principles, very important. Wanted to thank the panel, and I wish all of you a good day and good night. Thank you very much. We're done. We're over.